from the requirements of section 196, subsection 4 and section 5 of the Companies Act. Friends, section 196 and 197 of the Companies Act deals with managerial remuneration. If you recall 1956 Act, section 198, section 309, section 310, schedule 13, they were not applicable to private limited companies. Private limited companies were free to decide whatever remuneration they could pay to their directors. However, the Companies Act 2013 did not provide such freedom to private limited companies. While section 196, subsection 1, subsection 2, subsection 3, subsection 4, subsection 5, they said this section 196 was applicable to private limited company, but section 197, which laid down the limit on the remuneration, that it cannot be more than 11%, that it cannot be more than 5% if you have one managing director, cannot be more than 10% if you have more than one managing director or full-time director. This limit on remuneration was not applicable to private limited companies, which means you comply with 196, but you don't have to comply with the limits provided in section 197. So there was some requirement that 196 has to be complied with. Now, 196 subsection 4 and 196 subsection 5, they will not be applicable to private limited companies. 196 subsection 4 said that subject to the provisions of section 197 and schedule 5, any company which gives remuneration to its managerial personnel, it will have to pay remuneration by way of a which has to be approved either by your articles of association or by a resolution passed by your board of directors, and it has to be subsequently approved even by your shareholders in general meeting. So 196 subsection 4 said that resolution will have to be passed by the board of directors and it has to be subsequently approved by the shareholders in general meeting. And this requirement was subject to section 197 and schedule 5. Since 197 was not applicable to private limited companies, we were not bothered. But schedule 5, it did not distinguish between private companies and public companies. So this created additional problem. Schedule 5, if your profits were inadequate, it placed restrictions on the remuneration. Now then, since the schedule 5 was applicable to all the companies, there was one school of thought which said that even in case of private limited companies, the schedule 5 will become applicable and the remuneration to managerial personnel in the absence of adequacy of profits cannot exceed the specified quantum. This notification provides a major benefit because 196 subsection 4 will not be applicable to private limited companies. Similarly, 196 subsection 5 will not be applicable to private limited companies. Only section 196 subsection 1, subsection 2, subsection 3, these three subsections will be applicable even to private limited companies. All others will not be applicable. So private limited companies are free to pay any remuneration to their directors. They don't have to pass shareholders resolution for payment of remuneration to directors. They don't have to pass even board resolution, technically speaking. But then who will approve the resolution? So board resolution even otherwise would be a necessity, but no shareholders resolution will be necessary for private limited companies to pay remuneration to their directors. Complete freedom, almost same as the 1956 Act. But subsection 1, subsection 2, subsection 3 of section 196 will be applicable. Subsection 196 subsection 1 says that a person cannot be appointed as a managing director and manager at the same time. Subsection 2 says that the contract period cannot be more than 5 years at one point in time. And subsection 3 says that these three individuals cannot be appointed as managing director. If you are a person of unsound mind, if you are an undischarged insolvent, if you have been convicted of any offence involved in moral turpitude, then you will not be allowed to be appointed as a managerial personnel. These conditions will continue, but all other conditions will not be allowed. So more or less, total freedom to private limited companies as far as remuneration is concerned. Friends, these are the major exemptions which are applicable to private limited companies. I can tell you that yes, life for private companies at 2013, even otherwise, is a very large can of worms. And you will never know what provision of that you would not have complied with, and or what would befall on you for such non-compliances. Absurd provisions have been made applicable to private and unlisted public companies. For example, section 195 of the Companies Act, which says insider trading should not be carried out. Insider trading in shares of companies. I can understand insider trading as a concept as far as listed public companies are concerned, but I don't understand the concept of insider trading as far as private companies are concerned and unlisted public companies. Unfortunately, that particular section is applicable even to private companies and even to public companies. Every trading in a private company is always an insider trading. Every trading in an unlisted public company, unless you are placing the shares with a strategic investor, it is always an insider trading. And the penalty for non-compliance is 25 crores of rupees. 73, which dealt with deposits. A new section has been introduced by the Companies Amendment Act, which says that if you are accepting deposits in violation of the provisions of section 73 and section 76 of the Companies Act, the penalties may range from 2 crores to 20 crores. So the consequences of non-compliances are very, very huge. We have the concept of minimum penalties, which has been introduced by the Companies Act 2013. Thus, understanding the life for private limited companies after this exemption notification certainly will be much, much easier, because the filing requirement will reduce to a great extent. Secondly, except for 185, which has been a major disappointment as far as these exemption notifications are concerned, other provisions, the private limited companies would be in a position to avail the benefit of such provisions. I would like to repeat, as far as related party transactions are concerned, don't leave this hall with the concept that section 188 doesn't apply to private limited companies at all. It is not so. I will repeat, 188, there are only 2 benefits which are available to private limited companies as far as related party transactions are concerned. What are those 2 benefits? In the list of related parties, as far as private limited companies are concerned, now you have one party which is less. You have one less. Which is that lesser party? Holding company, subsidiary, associate, fellow subsidiary. And the second benefit that you have is that if you do a transaction which in volume requires you to pass a special resolution, then even related parties will be allowed to vote on such a transaction. That is other benefit you have. Otherwise, if you are a private limited company, if you are doing a transaction under section 188(1), if the transaction is with a related party listed in section 2 subsection 76 clause 1 to 7, then you will have to pass a board resolution. Now, if the quantum is more, then you will have to pass a special resolution. The only benefit is your related parties will also be allowed to vote. The exemption, suppose this transaction happens to be in the ordinary course of business of a private limited company, and if it is at an arm's length basis, then even a private limited company need not comply with anything. Right? So I think this is all about related party transactions as far as private limited companies are concerned. The exemptions which have been provided to private limited companies by the 5th June notification. If you have anything else that I need to touch upon, if you have any queries with respect to these matters, you can ask any question. I'll be glad to answer. Thank you very much for listening.
Bidder share capital.
Yeah.
Section 73 can accept deposits, loan from shareholders to the extent of one-time capital and free reserves.
Yes.
And for this purpose, free reserves do not include share premium. Can it be said that share premium for this limited purpose will form part of paid up capital? Can it be argued that?
See, as far as capital is concerned, it has been very, very clearly defined. And for the purposes of subsidiary, if you remember, we even have the total share capital defined in there. So share capital at no place and never in the last so many years of companies that has ever been treated as inclusive of share premium at all. Wherever the law specifically wanted share premium to be included, the law has clearly stated so. I don't think it would be worthwhile arguing that share premium would be part of capital. On the other hand, I would argue that share premium should be treated as part of reserves, though it's not called as reserves, but it is basically shareholders' funds and it should be treated as part of reserves. Free reserves, that's right. It's not, it can only be capitalized, but to that extent, yes, we have a problem. That's all. Thank you very much, friends.